There are roughly 31 adults who are in this case. They are both people who want to get married in a state that does not allow same-sex marriage, or people who are married elsewhere and want their state to recognize their marriage from out of state, for example, to have their name on a child's birth certificate.
Greg, did we get a sense of where the justices were leaning in this case? And is Justice Anthony Kennedy, who did write the court's 3 prior gay rights decisions, is he still considered the swing vote?
He's certainly the swing vote, and we got a little more sense of what the justices were thinking today. But the questions from him and from a lot of the other justices went both ways today. The bigger evidence is you have to look at what the court did a couple years ago with a big gay rights decision, and look at how the court has let so many states start same-sex marriage because of court decisions since then. There is a movement that this court has allowed to happen. We now have 36 states where gays can legally get married, and this court has let that happen. So that might be the biggest evidence that the court is moving in the direction of saying it is a constitutional right nationwide.
Greg, you mentioned a movement that the court has let happen. Is this something that we can go back to that Roe v. Wade decision which legalized abortion, and some critics said that the court at that time did not let a movement happen?
Well, that will certainly be something that people talk about. And one of the people who has suggested that criticism is Justice Ruth Bader Ginsburg, who's one of the most liberal of the justices. She said that the court moved too far, too fast in Roe v. Wade. In gay marriage, the court, keep in mind, could have issued a ruling 2 years ago, but decided not to. Instead, decided to let the number increase on a state-by-state basis, let popular opinion move in the direction. We now have about 6 in 10 Americans who favor same-sex marriage. So it may be that this is a different case where the court has actually waited long enough that the decision will be accepted by the public.
Greg, one of the arguments in favor of same-sex marriage, as you know, is that landmark Loving versus Virginia case in 1967. The court at that time ruled that preventing interracial marriage was unconstitutional. What are the similarities between the cases?
Well, there's certainly the similarity that the parties are arguing, look, this is a fundamental right and we want equal access to it. It's the same thing that the interracial couple did in Loving versus Virginia. One potential difference, and certainly what the states who are defending their same-sex marriage bans are getting at, is that traditionally marriage has been between a man and a woman. That's been part of the definition of marriage, they say. It was not the case in Loving that the definition of marriage meant it had to be 2 people of the same ethnicity. So they're saying this is a real fundamental change in marriage to let 2 people of the same sex marry, and that, they say, distinguishes it from the Loving case.
Greg, can we expect a decision in June? Is that about right?
Probably late June, Mark, probably right about the same time we get that big health care decision.